Hello. In this video I'm going to talk to you about problem questions and really about a very common question and a very common area of concern for students, which is how you can incorporate academic material, academic journal articles or monographs into your answer of a problem question. Now, in relation to essay type questions, this is comparatively straightforward. Essay questions will often ask you to critically evaluate the law in some way or another, or even to consider reforms. Now, in that way, of course, it lends itself quite nicely to journal articles because that's usually what most academics are doing, either drawing attention to particular problems in the law or suggesting potential reforms. But within problem questions, of course, your focus isn't generally to evaluate the law, but rather your focus is to discuss the potential for liability in relation to a particular set of facts. And so it's much less obvious, of course, how we would then be able to incorporate, and even if we want to incorporate, academic material. Now, this isn't true of all problem questions. Certain problem questions in different institutions may well ask you both to discuss and critically evaluate the law as you apply it. In that kind of situation, it's actually pretty straightforward, of course. You can do your application of the law, and you can also then take a sideways look and say, as so-and-so has demonstrated within so-and-so journal article, this is actually a controversial area of law, or there's been reforms by the Law Commission, or recommendations for reform even by the Law Commission. So in those kinds of questions, it's more straightforward. But once if the question simply asks you to discuss liability. Now, what often happens when a question simply asks you to discuss liability, a very common approach from students, is to analyse the question in the normal way, applying the law to it, discussing whether there's liability or not, and then at the end to suddenly think, I need some kind of journal article, so I'll just tack something on. By the way, reader, I've also read something about this by Ashworth or by David Ormerod or whoever it might be, and this is a little quick description of the article which I read. Or the Law Commission have also looked into this is a little description of what they said. Now, you will get some credit for that. It demonstrates wider reading, it demonstrates some engagement with the academic material, but in terms of answering the question, it doesn't really do very much. The question asks you to discuss liability. What you're doing is something quite different. You've discussed liability, now you're just telling me a little story about something you've read. So ideally, when you're answering a problem question, you want to incorporate further reading and you want to demonstrate that wider understanding. There's usually three main ways that we might recommend you can do that and actually be able to use that wider reading and that academic material in order to help you answer the question, in order to help you discuss liability. Now, the first one is essentially to explain an unknown. So there'll be a lot of times when you're answering a problem question where you'll reach a certain stage in your analysis and actually you don't know the answer. It could go either way. A common example might be, for example, the third step of will and intention. So intention as defined within the case of willing makes us look as, is the result a virtual certainty? Does the defendant foresee it as a virtual certainty? And then it's up to the jury whether they find intention or not. Now, when it comes to applying that third step, the answer is unknown. It's simply a jury question. We don't actually have the legal criteria to help us predict what the answer is going to be. Now, for you, when you're answering a problem question, of course, and you have to say whether you think there's likely to be liability or not, this creates a problem. It creates an unknown. Now, to help you explain that unknown to your reader, it might be quite useful to bring in some academic commentary and say, this is an unknown, acknowledge the uncertainty, but as, for example, Norrie in his article after Woolen says, this is a problem for then being able to have predictable outcomes of cases. So it's not simply an unknown in the sense that you're ignorant, but rather it's an acknowledged unknown within the law, which you're acknowledging and recognising through academic material. And there's lots of areas like this. So my example I gave obviously was the Woolen definition of intention, but equally I'm sure you can think of many areas in relation to causation, for example, where there's unknowns within the law, where you reach a stage where actually the law doesn't tell you the answer. Or for example, gross negligence manslaughter, when we reach the final stage of what is grossness. Again, there's a lot of uncertainty and you can use the academic material to help explain that uncertainty to your reader. Now, a second way for using academic material, and this is perhaps the more common one, is where you do have an answer within the case law, but perhaps that case law is contradictory. Or where there's an absence of case law, but you've got an academic material that suggests a way the courts should go. Now, where you have that clash of cases, so you're not sure which one will apply, or where you have an absence of case law, but you have academics suggesting how the law should be taken, you can acknowledge again that uncertainty to your reader. You can acknowledge the clash of cases. You can acknowledge the absence of cases, perhaps. But then rather than simply saying, therefore we don't know, we'll have to see what the court decides, you can reference an academic journal article and say, Although there is this uncertainty, if, for example, they follow the approach by Horder or by Herring, then this is the direction they're likely to go. An example might be in terms of uncertainty, something like transferred malice. So Jeremy Horder has written an article on transferred malice where he suggests there should be a remoteness principle in certain circumstances, and we discuss that within chapter 4 of the book. Now, it may be that if the scenario envisaged by Jeremy Horder comes up within a problem question, you could say, actually, at the moment, there's an absence of case law on this. However, interestingly, if the court chooses to follow the approach recommended by Horder, this would be the likely outcome. And you can then comment critically on that, and you can say, this is the outcome recommended by the academic, but actually for these reasons I don't think the court will go that way, or even I don't think the court should go that way. Or equally you could say, actually it's likely that the court would adopt that view and this is why. So again, basically you're dealing there with an uncertainty, either, as I said, through clashes of cases or through an absence of case law. And you're using the academic material to help you answer the question, to help you say whether you think liability is likely or unlikely. And then the final of the three, is perhaps the most unlikely, but does occasionally come up. And this is where you have a case on point, you have valid authority, but actually that case has been so fundamentally criticised by a host of academics or by a particularly powerful journal article that actually you begin to doubt whether that precedent is going to be followed by the courts or not. An example of this might be, for example, the Anderson case in relation to conspiracy. So in that case, most academics would agree that the case has basically misinterpreted the mens rea of conspiracy and caused quite a lot of confusion within the law. Now that case remains valid authority, but actually I think you can quite legitimately say that the breadth and degree of criticism of that case means even though it's valid authority, it's likely that in practice, i.e. within your problem question, that the court would either overrule it if they had the authority to do so, or they would find a way of distinguishing that case and going with the more recognised authorities. So in this way, again, you're using the academic material to help you answer the question. So just to summarise, the three ways in terms of good practice for academic material within problem questions. Firstly, explaining an unknown, simply saying this is an uncertainty within the law, and this uncertainty has also been highlighted by academics within this so-and-so material. Secondly, finding a solution to an uncertainty or finding a solution to a clash of cases. So this is an area of uncertainty, this is a clash of cases, these are a set of academic articles which have suggested routes out of that uncertainty, and we consider which one the court's going to apply. And finally, where there is authority, but actually it's been so fundamentally criticised that we doubt its continuing authority. Thanks very much.